Scott joins us on Thursdays. He's so terrific to give us time. And I always mention that he's on BBC, he's on London radio, he's on in New York, he's on Fox News Channel, he's in San Francisco, he's in Los Angeles, he's on all of these different media outlets. And finally, I just decided it would be fun to share with you a little bit of David Katz on New York television. Go ahead and roll it, Albert.
Mayor Eric Adams under the microscope again as the FBI continues its investigation into possible illegal foreign donations for his 2021 mayoral campaign.
There's certainly some bad looks to some of this stuff.
This time, federal officials want to know whether the mayor received free upgrades when flying Turkish Airlines, Turkey's national carrier, in exchange for political favors.
I don't think they can prove that there was a quid pro quo.
This investigation is part of a wider corruption investigation involving Turkish airline executives, aides to the mayor, and the mayor himself. David Katz is a former assistant U.S. attorney.
They can prove that there was a quid. Yes, he got upgrades, but they can't prove that there was a quo. They can't prove that he did anything corrupt for Turkish Airlines or for the government of Turkey in exchange.
In November, as part of this probe, the FBI raided the home of Mayor Adams' top campaign fundraiser, and then a week later, they seized his cell phones. The raids come after the approval of a new Turkish consulate when Adams was Brooklyn Borough president. According to the New York Times, Turkish officials asked Adams to resolve building safety violations that were preventing the Turkish consulate from opening in Manhattan. Adams allegedly reached out to the then FDNY commissioner when he was still borough president.
If they report that there were fire problems, if they report that it got opened prematurely on account of the mayor's influence, that's one thing. But to just say that he tried to get it opened up and they dragging their feet and they opened it up and it's all fine under fire regulations, I don't think he did anything wrong.
The mayor's attorney responding to the allegations. In a statement to Fox 5, he says, quote, as borough president, the mayor consistently disclosed his official travel to Turkey, did not receive any improper upgrades, and did nothing inappropriate in exchange for an upgrade. Speculation is not evidence.
I think they're pretty much conceding he did get the upgrades. Question is, did he do anything corrupt in exchange? If they can prove that, the FBI has a stronger case, no doubt about it. But I still think on balance, the mayor will not be indicted as a result of this investigation.
I love it. That's our David Katz. Sorry, I think the volume was a little low. That's what I'm seeing in the chat. That's why I laid out. But how about it for David Katz, everybody? Former federal prosecutor and now working the defense side of the table. Hello, sir.
Great to be with you, Mark.
That mayor in New York, he's hip deep in it, I guess, huh? Yeah.
Well, it was fun to be on that show, and it was also broadcast from Lincoln Center, Mark. Can you hear me? It was also broadcast from Lincoln Center on the west side of Manhattan. So it was just a great backdrop with people getting out of the matinee of Turandot behind me.
Look at you. You're a cultured guy. Well, let me ask you about something that just happened, and it made me wonder what this is a little bit of blindsiding you, but I know you've formed an opinion on it. O.J. Simpson just died. We did a pretty good chunk at the beginning of the show with one of the, if not the first reporter on the scene, and then covered it wall to wall, both at the crime scene at Rockingham and in the courtroom. And we sort of reviewed some of the highlights and some of the things that were memorable about the trial, and obviously he was acquitted in that first trial. My question to you is a legal one. As you looked at the legal part of it, leaving aside what seemed to be clear based on what one could surmise based on what we knew, legally, did you see that the prosecution did not make a good case in that first O.J. Simpson trial?
I thought that they presented more than sufficient evidence. I thought that if I had been a juror and I heard a lot of the trial, focused on the trial a lot, I would have found him guilty. But, Mark, you're not blindsiding me because we haven't even spoken about this. Pat Thurston and I used to speak about this because she was on with Erwin Chemerinsky at the time, who went on to be dean of my law school, University of California at Berkeley Law School. But Pat and I used to talk about this. I was an OJ commentator. That's really where I started doing commentating on legal matters. And I fell into it. It's a great story if you'd like to know. But I was on TV on KCAL, Channel 9 in Los Angeles with Pat Harvey during the Bronco chase. They were just looking for lawyers.
Wow.
that they wanted on the air. And I had a fraud case, which had been on the front page of the Daily News. So I think they went through their Rolodex with every lawyer who'd been in the LA Times, and then they went on to the Daily News. And I was on the front page that day. So a producer called me up. It's always hard to get a hold of me because there's like 10 David Katzes, right? But he got a hold of the right David Katz, invited me on the program, and the slow speed chase took so long. Remember, it preempted the NBA finals basketball game, and suddenly every station, you looked up on the TVs, every single station, from sports to news, the sitcoms, were preempted. Everybody was watching, yes, this slow speed chase. And they had a psychologist on there, and they asked him, if you turn to the left, if you turn to the right, what does it mean about your childhood? What does it mean about that? And I said, I think he's turning left because that's where his house is he's going back to. And they love me. They love that line. He's turning left because that's where his house is at. And then they had me on all the time. And we did a show on Channel 9 with Pat Harvey called OJ Tonight. The entire news and sports and weather was worth 1/2 hour, and OJ was worth the next half hour. So at 10:30, we came on with OJ Tonight. It was me and another commentator. I was considered the sort of pro-prosecution one because I had recently left the U.S. Attorney's Office. The other was more of the straight criminal defense attorney. Well, don't you see there was reasonable doubt on account of this, and that didn't go in well. And that guy was really well cross-examined by Johnny Cochran and the other defense attorneys. And we did that every single night during the OJ trial. And people who weren't around then or who were under a rock and weren't watching television at the time, people had OJ withdrawal. That was a real thing. It was like the show that they watched every day. They talked to their friends about it. And when it suddenly ended, especially in an acquittal, so there weren't post-trial motions, there wasn't sentencing, it ended kind of cold turkey, like The Sopranos or like Mad Men. And people really missed it in the same sense. There was OJ withdrawal. And, you always play that clip, Mark. There's never been anything like it. Truly, for younger people, there was never anything like it. We never had a televised trial. We had depictions of trials. We had like the movie about the Scopes trial. And we had Perry Mason, which tried to approximate the high moments of a trial. But we never had anything like OJ. And people got so into the narrative. They got into the different characters. There were people that I saw Cato Kalin, the guy who slept on the couch, on national TV today. And it had all these characters. It had a guy named Al Kamens who drove him around. It
Al
had
Cowlings, yeah, that's right.
There it is, yeah. And they had a guy who said, OJ told me a dream, and Judge Ito led in the dream. And then these are the huge days of late night TV. So, of course, Jay Leno was the top show then. He lampooned it every night, and he had a bunch of fellows called the Dancing Itos. And so when Ito issued, we haven't had the dancing loose cannons, right, in the Trump thing. We haven't had.
That's actually really that's a great point. I was making the point in the first hour. There was an industry that grew up around it, and then there was even a post-trial industry. Marcia Clark got a talk show I was mentioning, and there were even dramatic depictions a few years after the trial ended. There was an OJ fever, and what was revealed about the justice system to me, I thought was interesting as well. In a way, we were seeing what happens in a court, but in another way, David, it wasn't really representative of what happens in a court, right?
Well, he had this terrific defense team. They were called the Dream Team. There was Johnny Cochran, there was Bob Shapiro. I knew both of them well. Then he brought in this group from the Innocent Project, and they've gone on to do great things, with people
Barry Scheck, you mean, those guys?
Yep.
Yeah.
Wrongly incarcerated. And then the DNA was a huge issue. And I still remember Larry King asking, so what's this DNA? With that great voice of his.
What can you tell us about the scene?
Yeah.
Yeah. I went to the Bronx High School of Science, but I hadn't really kept up with, every aspect of the DNA. And then everybody got kind of allotted to their own station. So I was on 9, and I looked up on the board because they had all the TV screens in the newsroom. And I think 4 of my colleagues from the U.S. Attorney's Office were on at the same time. There was a woman that I knew from the U.S. Attorney's Office who was on 2. There was a fellow named Manny Medrano, a good friend of mine. He was on 4. And so it went. And the famous person from that era, from the commentators, was Greta Van Susteren. She was on Fox 11 in LA, and she went on to get a big contract with Fox and was on there for years. Can I
She was
tell
sort
my
of an
Johnny
OJ.
Cochran?
She was an OJ advocate a bit on, as I recall. But
Well,
when
but Mark, if
what
I could just interrupt you for 1 second, we were considered the most pro OJ station, KCAL.
mhm.
And I hope you love all these stories. I mean, OJ has just passed, and I don't know how much
Yeah,
time you
no,
want
of
to
course,
spend
no.
on.
I'm glad we're spending a minute, but back to my question, which was, were we seeing what a real I mean, this is it's a celebrity case. There's all this money. There's the dream team you talk about. There's this the judge who seemed to be celebrity struck also, meeting in chambers with Geraldo and all. I mean, there was a madness to it all. As you say, there's an insatiable appetite on the part of the public for more analysis. I mean, your phone was ringing off the hook at the time. And I guess what I'm asking is, can you, and then of course what was revealing about a jury, we talked about this in the first hour, was it's all about the jury. The jury didn't see that evidence as sticking. They saw it quite believable that the cops could have planted that evidence because they had seen it in their own community. And I'm wondering if you just speak to the trial itself. What could we take from the trial about the justice system in America?
Well, I know that you did a murder mystery a while ago because I saw it. It was great, about the Von Bulow case, the one that made Alan Dershowitz famous. Since then, a lot of people think he's become infamous, but it certainly made him famous. And he had that book, Reversal of Fortune, that became the movie. So we had seen high-profile acquittals before. I'd worked only on the pretrial appeal of the John DeLorean case. Other people that I had nothing to do with tried that case. It ended up being an acquittal in federal court. So we'd seen high-profile acquittals. I think the thing that surprised me was I thought that OJ had a very fair trial. I thought, generally speaking, it wasn't that skewed. I didn't think that Judge Ito was starstruck, given that he decided to have the case, on national television, and this fascination that started to revolve around it, and the personalities and everything, and the dancing Itos on Jay Leno's show and all that kind of stuff. I thought that Judge Ito did a good job. I don't think that he was, starstruck or anything like that. I think the defense attorneys did a particularly good job. It was downtown, a largely minority jury. And one of the interesting things in the case was that Gil Garcetti, who was the district attorney at the time, could have pursued the case in Santa Monica. The events happened in a place where it would have been logically venued in Santa Monica. He decided to bring the case downtown. And at least according to sources I had at the time, because I was on television so much, I had sources. I had people trying to spin me, right? So believe him or don't believe him. But I had sources that told me that Garcetti was willing to take an acquittal if that's what ended up happening. But he couldn't take challenging minority jurors the way they're often challenged. Now, you can debate our system. There are a lot of racial stereotypes that go on both sides. They're not supposed to. They're technically illegal. There's what's called a Batson challenge in federal court, that you cannot peremptorily challenge a juror, even though you have peremptory challenges to, let's say, 6 or 8 of the prospective jurors. But you can't challenge them solely on the basis of race. So the judge will say, are you challenging that person solely on the basis of race? And the prosecutor will say, if it's, typical situations, the prosecutor, it's an African-American jury, that's been the paradigm. No, it was their answer about the police. That was my reason. It was the way that they, wore their hair in dreadlocks, something like that. That could be legitimate. You weren't challenging them because they were black. You were challenging them because they were the black person with dreadlocks. And it would go the other side too. The government wasn't allowed. The prosecution wasn't allowed to challenge based on that. But still, there would be a perception. Let's say 12 people got brought in, and it ended up that Garcetti and his prosecutors had challenged 10 of those minority jurors for, some kind of cause or on their peremptory challenge. At least my source said that Garcetti was not willing to live with that. He was willing to live with an acquittal if it came to that. And so he brought the case downtown. He also didn't go to a grand jury. He went to a preliminary hearing, for those who remember the case well. And that was the so-called trial before the trial. And they spent like 2 weeks on this trial before the trial, which exposed the prospective witnesses to another round of cross-examination by the defense attorneys. It seemed odd that the prosecution, when it could have gone to the grand jury and avoided having witnesses presented publicly, because that was also televised, and cross-examined, that they would have gone to that. So it was really fascinating, all of the things that happened in that case. But I think in general, there was a fair trial. One more story, because I was on KCAL and because we were perceived as the most unbiased against OJ, there was a juror who got thrown off the jury in the middle of it. And she chose KCAL to tell her story. And I was there with Pat Harvey and this juror. And I mean, everybody wanted to talk to her because she'd been on the jury. We wanted to hear what her impressions were. And to a certain extent, to a large extent, she could talk about what her impressions were. She'd been discharged from the jury. And she had the famous line that she was really mad at the police and the prosecution because they hadn't given OJ time to grieve. And of course, all the wags and the cynics, right, said, time to grieve. You know, if you kill your wife, you may get arrested before you really have had time to grieve. And back and forth it went. You know, Mark, people were very polarized on this case. A lot of it was on racial grounds. And then when the jury's verdict was announced, they say it was the second most watched event after the 1969 landing on the moon, because we knew the night before that there had been a verdict. And we didn't know what the verdict was going to be. That was going to be read at like 9:30 or 10 the next morning. And that was supposedly the second most viewed event at the time. And one last story, Mark, because I love all this. We were going to do a huge thing on KCAL for an hour the night before. And I was going to advocate that, of course, based on the evidence and the law, from what I had seen during the trial, he was going to be found guilty. And somebody else was going to take the other side. The person who'd been a criminal defense attorney his whole life was going to take the other side. I had to go to San Francisco that afternoon for an appearance the next morning. And so I missed proclaiming to the world that I thought that OJ was going to be found not guilty. But I'm telling that story just for you, Mark Thompson, years later.
Lucky. You know, it's funny. If you hadn't been positioned that way, the way they were going to position you with the not guilty, with the guilty, you representing that, did you feel at that time in your gut, David Katz, that he was going to walk, that he was going to be acquitted?
No, I really did not, because I thought that there was evidence that they had found in the case that even if Mark, oh my goodness,
Furman,
he was the most
Furman, the guy who used the
Mark
N-word.
Furman. Yeah, there's so many famous Marks, including the Apostle, right? But he was the famous Mark of the case. Mark, say it again. Furman,
who
was
with
used the N-word.
F. Lee Bailey, I guess, was, as I recall, questioning him, right? And he said, "Have you ever used the N-word, sir?" And he said, "No, absolutely not. I haven't. Marine to Marine, I haven't. You know, whatever, right?"
And he told his story to a reporter. Like, everybody got the fame bug, so you know, they were gonna write a book. They were gonna have a TV show. And Furman had apparently told this writer or ghostwriter, and I think she had even tapes. I don't want to.
Exactly. She had tapes with him saying the N-word over and over again.
So that was a terrible look, of course. But even if they were trying to frame OJ, and my view on it was that if there was one black man in America that the LAPD did not want to frame, it was OJ Simpson. He was the big friend of the cops. He was a totally establishment person. May he rest in peace. But he was a totally establishment person. I thought he was the least likely person that they would try to frame or railroad. But even if you believe that narrative, there were places that I thought, following the evidence, that nothing could have been planted. I thought there were other things like that. And I thought that, you know, it was just implausible. You know, where was he? What was his alibi? All these other things that pointed to his guilt. So I felt very confident that was a defensible position, that he was going to be found not guilty. I got to tell you one more story, because I just love all this stuff. I knew Johnny Cochran really well. I knew a lot of these lawyers really well because I'd been an assistant U.S. attorney into like 1990. And this trial was, you know, in the early 90s. So I'd come out of the U.S. attorney's office just a few years before, and I knew, you know, a lot of these people. I had tried a case, swear to God, I had tried a case against Johnny Cochran, and I had won about a couple of years before that. And it was in federal court. And Johnny didn't articulate this phrase, but I think it was percolating in his mind, because his defense was basically, if the shoes don't fit, you must acquit. Now, he hadn't come up with that great expression yet, but two guys, it was like that Get Shorty movie. Two guys came from Miami. Each one had a suitcase. The mule had the cocaine in the suitcase. But all the luggage in that suitcase was the mule's. Mr. Big, who was represented by Johnny Cochran, Mr. Big didn't have any of the clothes in his suitcase. So if worse came to worse, Mr. Big, Johnny Cochran's client, was going to say that the suitcase and the cocaine in it and all the clothes in it. So Johnny was, going through what size were the shoes, right? If the shoes don't fit, you must have quit. But he didn't have the rhyme. He was still working on that great line. He ended up getting found guilty. And the big mistake that Mr. Big made, even with his plan to get acquitted if it came to that, was when they actually reached into the mule's suitcase and they found the cocaine and got real near it. He rabbited. And that was all these great, argot slang expressions. But to rabbit was to mean to run from the scene of the crime. So instead of playing it off and being cool, like, well, I don't know, somebody else's suitcase, he freaked out and ran through the airport. And so when you added that piece of evidence to it, Johnny's client was convicted, but he had two black jurors. And when he started to give his closing argument, the way he had that, he was good with everybody. But those two black jurors, I said to myself, this is going to be 10-2. We're going to be trying this case again. And then the two black jurors voted guilty, too. It was a unanimous guilty verdict. And of course, Johnny Cochran was the sort of person, he was a wonderful person. And we became really good friends after that, which is the way the world should be. It's the way people think it is. You fight like hell. You both, don't give any quarter. You fight within the bounds of ethics. And then you run into each other a month later and you have a drink together. Johnny was that kind of guy, a wonderful guy.
Sadly, I think the culture of media has now made those moments harder, made the kind of relationships harder because everybody is, their brand is hate a lot of the time. And, you've found it in some of these high profile trials as well. I love these reflections and the audience loves it as well. And, we think of Johnny Cochran as sort of the Patrick Mahomes of lawyers, and then you tell a story about, well, I'll tell you, I beat Patrick Mahomes that day in court. I mean, it was in a very high-profile case. I want to ask you about, now moving off of the O.J. Simpson trial, I want to ask you about this decision in Arizona. The court now taking up this case and citing a law from the 1800s that, predated even the statehood for Arizona. Can you speak to just the legal underpinnings of this and what the future might be?
I think as a pure legal matter, it makes sense. It's easy to ridicule, make America 1864 again. But think about it. There's a territory. The territory passes a law against normal murder, right? And it has grades of murder, then it has manslaughter. And then there's never anything that's passed from the time that it became a territory until it became a state until now, right? So it would be governed, the law of that state would be governed by that 1864 law when they were a territory. Shame on Arizona that it never passed a law after that. And there were, of course, efforts, all blocked by Republicans, all blocked by anti-choice advocates, to ever change that law. And that Carrie Lake down there, who now says she's against that 4-2 decision of the Arizona Supreme Court, said the exact opposite. She said, if they get rid of Roe v. Wade, we've got this great old law in Arizona that will kick in and be in effect. Now that it's kicked in and it's in effect, a lot of people like her and Trump are going, oh my God, because this was a talking point. This was a rallying cry to get, Republicans, some Republicans, and anti-choice advocates to the polls and to make a big issue and to contribute to the Republican Party. And now the chickens have come home to roost. So legally, it seems to me that this is a statute. You can get rid of this old statute by passing a new statute. And the Democrats tried immediately the next day to pass a new statute, but the Republican-controlled legislatures down there defeated their efforts, wouldn't put the bill forward, and they adjourned for a week. Now I think Trump and Lake and all these people are going to figure out, this is just hurting the Republicans politically too much. We have to put this in the rearview mirror, and they'll pass some kind of statute down there that will put this in the rearview mirror. Will the advocates of choice agree with that statute? No, but it will not be a total, complete ban with no exceptions, even for rape or incest, which is the state of the law down there, because that was the 1864 Territorial Act down there in Arizona. That's still in effect because it's never been superseded or changed.
Yeah, it's interesting. The laws that coexisted on the books at that time, one of them was about beating your wife, I think. You had to make sure that the curtains were drawn before you could beat your spouse. I mean, it's like just a again because they didn't want that to be exposed to the public type thing. You realize the antiquated and horrifying orientation of those who crafted this legislation to begin with, and the notion that it could be dusted off and presented this way, and as you say, enshrined now, is something that is yet another bizarre twist in this country that we live in. You characterize it so well. I mean, they are going to have to figure out something, because otherwise this will haunt them all the way to the election. Not to mention the real effect it has on women. I mean, it's just this is an awful on healthcare. I mean, it's an awful thing. So,
Mark, one of those advocacy groups figures out how far and how long it would take a person to get an abortion if they live in certain places, like let's say Georgia. It's hundreds of miles, and it's a lot of time. So someone now in Arizona, assuming they could get off work and they had the money and could figure out how to do it, would now have to drive many hours and hundreds of miles, because they'd have to go to New Mexico. You know, Arizona's a big state. If you're in the middle of Arizona, you have to go to New Mexico, take time off work. You could come to California. Luckily, California and New York and some other states have made it very easy, if you can get to our states, right, to have this procedure. And so that's certainly something. And then even the medical, the pill, right, the abortion pill, would be illegal in those states, because anybody who gets you the abortion pill, as things stand right now in Arizona, or any doctor who participates, or even the pharmacist or someone, I guess the Uber driver, if they know they're bringing you that pill, would be technically in violation of the law. And of course, the doctors and nurses rightly are freaked out down there, because the decision, the Fortitude decision, says this will put doctors and other health care professionals on notice that they are violating criminal law if they provide or assist in an abortion. Talk about chilling. And people say, well, that may or may not go into effect for 2 weeks. It may not go into effect for 45 days. Really? Do you want to be a nurse or doctor doing anything to provide someone with an abortion when you're facing, forget that you might not have your liability coverage, but you get dragged into court. And the attorney general down there says that she won't prosecute, right? But you're in some little, anti-choice, part of the state, and some DA, drags you into court, and you're a doctor or nurse. So this is a disaster down there. It absolutely has to be cured. And you can see that, this is what a lot of the Republicans had in mind when they put these 3 justices on the Supreme Court to overturn Roe v. Wade. It's not just an intellectual talking point. And this has been their goal. The Federalist Society and their ilk have had this as their goal for 40 years, Mark, to pack the court with these justices. And it just was not that huge an issue for Democrats and liberals and people who were pro-choice, because it seemed really like Roe v. Wade was the law of the land. Maybe people got a little bit complacent, but they've gotten very uncomplacent now. And this is a terrible topic politically for the Republicans, because if people are talking about this, 20-30% more people are for sensible choice laws than they are for what we're seeing in Arizona and what we saw from the U.S. Supreme Court.
I like that you use the word complacent, because I was talking about complacency the other day when this happened. And I think Kim and I were speaking of, now this is going to motivate women to get out, and you're going to hear from women. But my vision was, how come with that open Supreme Court seat in 2016, we didn't see a show on the part of those who recognize the power of infesting the court with people of the sort that rolled back Roe? I would have liked to have seen, to me, it was clear you could be a single issue voter on just that issue at the time. And I thought it was defensible, to just vote blue for that reason alone. And now we've seen the effects, and it's frightening, and it's not over. So we must move on, though, and I want to ask you about what's happening in New York City. The Trump trial is an interesting one from a legal standpoint. I read more and more, David, that there are sort of legally tenuous relationships between what Trump was doing and the way they're pursuing this trial and the hush money case. Can you speak to this a little bit?
Sure. Well, when you say legally tenuous, I mean, it seems to me like a very, legitimate prosecution. The federal government decided that they didn't want to pursue this. I mean, you have to use prosecutorial discretion. I think that, the people who say, well, my goodness, Merrick Garland and his Department of Justice didn't go on this case as a federal violation. They went on Michael Cohen when Trump was in office. I mean, you can certainly say, well, Trump wanted to get Cohen, and Trump's Department of Justice wanted to get Cohen. And when you looked at it just from that point of view, once Merrick Garland and once a new U.S. attorney appointed by President Biden was in office in the Southern District of New York, how big a priority was it? I mean, everyone had seen the insurrection. Everyone figured the insurrection case was going to some kind of prosecution. You can also say that, they had other resources. They prosecuted an awful lot of very important cases in the Southern District of New York. So it doesn't mean that Trump was certified clean, but he'll certainly talk about the fact that these were righteous federal charges. They weren't brought, and he's going to say, well, they weren't righteous because they weren't brought. That doesn't follow at all. Trump also allegedly violated state law by the same cover-up of the payoff to Stormy Daniels done through Michael Cohen. And it seems very clear to me that these false entries were false because they said it was attorney's fees, and they weren't attorney's fees. Trump has never been able to show what service Michael Cohen was performing that entitled him to this monthly paycheck. And isn't it amazing that those monthly paychecks that Cohen got ended adding up to the amount that he had taken out of his pocket and paid off Stormy Daniels to make this whole thing confusing. And since he was going to say it was a legal fee, Trump had to give him enough money that he could pay taxes because he was going to declare it. It came in checks. Trump himself signed the checks. So it seems to me like a very legitimate case. But at the same time, the problem that I see in it is that in order to bump it up to a felony and not just misdemeanors, that Trump has to be shown beyond a reasonable doubt, Mark, to have known and intended to violate state campaign financing laws. So he has the defense, I only did it for Melania, I didn't do it for campaign violations. If they believe that, that would be, there would be a reasonable doubt. The reasonable doubt would be it's reasonable that he had a different motive. Likewise, if he only knew that this was a violation of federal law or there was some kind of federal regulation, campaign contribution, but who knew the state had such a thing? He really didn't know state law. Michael Cohen never explained it to him. He never read anything about it. Then it would be a misdemeanor. As I said before on your show, I don't think he's going to go to prison for this offense, even if he's found guilty. So you can say, what difference does it make if it's a misdemeanor or a felony? The point is that a jury unanimously convicted him of criminal violations, but you can see that Trump will ballyhoo the fact that it was just misdemeanors, this is, the mouse that roared, all of this to create a little misdemeanor. What's that, like a traffic ticket? They spent how much money going? They spent millions of dollars and years of investigation, and they gave all these people breaks so they could prove a traffic ticket against me.
Yeah, you really characterize it well. I guess when I was speaking about tenuousness, I was trying to speak to the way they were tying the business fraud to what you were talking about, which you kind of referenced it, that some kind of running afoul of campaign directives.
Well, Mark, that was the big case that they had this special prosecutor. I mean, I think Cyrus Vance, who was the longtime district attorney there in Manhattan, I think he really has some explaining to do. I see him on CNN and other stations, and he really hasn't explained, why didn't you pursue this while you were in office, okay? When you had these special prosecutors, you had these two people who knew this case inside and out, and he was going to bring both this campaign violation thing with Michael Cohen and Stormy Daniels and the falsified business records that Trump signed off on. Trump wrote those checks. They have him actually writing something. This guy who never wanted to touch anything or write anything. Plus, you have Michael Cohen testifying about it. But on top of that, saying that the apartment was 3 times as large as it was, that could have been criminal. That's a fraud on banks. I represent people who are charged with that sort of thing all the time. They would laugh at me if I said, well, why are you bringing this in federal court? This is what federal courts do. This is what federal prosecutors do. They bring case. Some people call the FBI federal bank investigators. They protect the banks. Sure. They protect the big companies. This is exactly what they do. If you lie to a big company, if you lie to a bank, and they can prove that you did it, as they could with Trump, you get prosecuted for it. So why wasn't all of that brought in state court? It could have also been brought in federal court, but it could have been brought in state court. It could have been done by Alvin Bragg's predecessor. Instead, he kind of left that in Bragg's hands, right? And Bragg decided not to pursue or to, sort of tamp down to keep looking at it. And eventually the special prosecutors, both very noisily resigned. One of them wrote a book. And yes, there was not a tenuous connection. Those cases logically belonged together in one big criminal prosecution. It left the Attorney General of the state of New York, right, Letitia James, to bring the charges as only civil charges. That's what she got the $450 million for. The lying to banks, to inflating the value of assets so that he could get larger loans than he was entitled to, so he could pay lower interest. And he ended up causing damage, Mark, of hundreds of millions of dollars. This idea is $450 million. Where did it come from? That's the advantage that you got. Trump, you got to disgorge the advantage you got by lying, by committing civil fraud. You've got to disgorge it like anybody else. You cause $500 million or $1 billion worth of damage. Guess what? You might have a court come back and say you owe $450 million plus interest. That's all that happened to Trump, but it's civil, Mark. It's not criminal. It could have been criminal along with this Michael Cohen case.
So well put. This is really great. And so there is a stretch here that you can convict Trump for the falsifying business records. That's a misdemeanor, right? Falsifying the business records, but that it might, if it was to try to do something else that was criminal, then you could make it, then it's a bigger deal. Then it's a felony.
My understanding that to violate the state criminal felony law, you have to have this intent beyond a reasonable doubt and know beyond a reasonable doubt that you're violating state law. So Michael Cohen says, I explained to him that we're going to do this thing. That's why I said to him that we had this discussion back and forth where Trump said to me, do it in cash. He's got the recording. Michael Cohen does. I think it's admissible because you can do that one party recording in New York. You can't do it in California. Be very careful if you try to do what Michael Cohen did in California. Apparently it's legal in New York. So he recorded Trump. He says, I didn't record Trump because I wanted to get him. The guy would bark out 17 different things to do, and I would listen. I used to make sure I did my little checklist. So that was what it was for, the checklist. And when I said, we're going to pay Stormy this money in a check, he said, no cash, no cash. So why does Trump want to pay him in cash? Michael Cohen's going to say, because I told him you're going to be violating federal and state law. And if you do this, if you believe Michael Cohen, well, there it is. He knew, Trump did, from his lawyer, that he was violating state campaign financing law by doing this false documents in the way. If you don't believe Cohen, and they're going to go after Cohen, right? Hook, line, and sinker, everything he's ever done, all perjury, all the things that are his convictions. And then the prosecutor is going to say, takes one to no one, right? Right. People like Trump don't hang out with bishops. They hang out with lowlifes and fixers like Michael Cohen. And that's who you bring to court to tell about it. And by the way, it's corroborated. Trump wrote the checks. And so that's what it's going to be. But it could end in a misdemeanor. I don't think that this case is going to end in a prison sentence. I joked with you about him meeting with Macron at the Rikers Island prison. People like that image. That's not what's really going to happen. One thing is interesting. Someone actually wrote an editorial since I made that joke. What would really happen if he was both incarcerated in state court, in a state prison, and he was elected president? And the opinion writer, who I thought explained it pretty well, would say that he would go to the federal courts and he would say this is a violation of separation of powers. The judiciary of some state is impeding my functioning as the president of the United States. And he would get a writ that at least as long as he was president, he'd be released from jail. So he wouldn't have to meet with Macron or have the nuclear button in his cell at Rikers Island.
That's just really wild. Here's a quick question for you from Phineas. David Katz, how do consumers prosecute? This goes back to the recording being surreptitiously wiretapped or eavesdropped on. How do consumers prosecute businesses for violating California and federal wiretapping and eavesdropping laws?
Well, if he's really serious about bringing a suit, I mean, he should speak to an attorney. Don't take my advice, on the podcast about it. But he should speak with an attorney, and there are remedies if you're recorded by someone. A lot of these recordings, they try to cover themselves. They say, we're recording this for training purposes or whatever they say, but you put on notice that they're going to be recording the call. If you're put on notice that the call is being recorded, you can hang up or say, no, I don't want to talk to you with a recording going. But it's the unannounced, right? It's the unannounced recording, the surreptitious recording. He should talk to a lawyer about it.
I wanted to see if there's anything else. People essentially are thinking now that it doesn't matter what happens with Trump's case because it's already been baked into MAGA's view of trying to get him back. I mean, that's certainly true that his base is unshakable. If he's in prison, on his way to prison, being tried on something that could send him to prison, it doesn't matter. But it matters to a lot of other people. And that brings me back to the bond. The bond, which we've talked so much about. I've learned more about bonds than I ever thought I would know. And I'm wondering, calling into question whether there is the liquidity to actually pay for the bond. The prosecutor now saying, hey, I want to see about this bond. And if this bond isn't kosher, I'm going to go after Trump properties and other assets to make sure that the state of New York has the bond secured. Can you speak to that?
Well, I think that you asked a real common sense question when this came up. When they posted the bond, you said, well, I mean, there's $175 million that sits in escrow somewhere. No, apparently, no, there is no $175 million sitting in escrow somewhere. If you go to like Chase and you say, I want to see the account for this payday lender who's now in the bond business and now posting the bond for their friend Donald Trump, no, there apparently is not $175 million that's sitting there. There may not be $10 million that's really sitting there. And they're apparently not a New York corporation, which, you can cooperate between the states. There's all these compacts and so forth, but it's much more difficult to collect on the bond. And the idea is that the minute that Trump loses the appeal, and I can confidently predict he will lose the appeal and owe a very substantial amount of money, that instead of having to chase him and his assets, you just go to the bondholder and you say, okay, turn that $175 million over to me. And if it's not that simple, then I think the court, the trial court or the appeals court will say, no, we're not accepting the bond. We're right back to where we started. Have another bondholder. You have 7 days to come up with somebody else with a bond, and we'll take a look, we'll scrutinize that bond. And if you don't come up with any bond that satisfies the $175 million, then she can go collect. This is Letitia James, the Attorney General. She can go collect, whatever that means. If it means start seizing the rents from his properties, if it means taking physical possession of some of the properties, it seems to me that's rather difficult. And also the optics are bad. Why play into Trump's hands? But figuring out the ways to actually collect that money without, going into, now he owns this stock, right? And supposedly this falling stock of his, this Truth Social, if it still has any value left at the time, that might be something. You can probably put a lien on someone's stock account or something. And that's what she'll do. She'll go collect the money because she is entitled to the money right now. That's the idea. Everybody would appeal. Everybody would delay. Everybody would go, ha, ha, ha. I'm going to keep this appeal going. You go and wait for your money. That's not the law. The law is that we presume the regularity of judgments. We presume that the trial court's judgment is a valid one. And you either pay it right now or you're subject to paying it, or you present the bond that the court demands. And if you don't present it, then you're right back to square one, where your creditor, the judgment holder, can go collect against you and collect against any asset that you have.
Yeah, it's interesting. I'm just looking to see the quote from Letitia James. Trump's bond is so weak that she's saying she may still go after assets. I mean, you never know how much of this is the kicking the dirt at the umpire, just to try to for that moment. I mean, there is some theater to all of this too, I guess, David. But it's a real possibility in the scenarios that you draw out. If there's no there, then she is entitled, I guess, to go after it.
In terms of John, I'm sorry, Mark. One last thing. Is in terms of people who think, Trump keeps getting away with it, this and that. He does have a $450 million judgment against him for committing fraud. By clear and convincing evidence, he committed frauds. I mean, the people who are going to vote for him think wow, this really is the guy they want to be the leader of the free world. This really is the guy that they want to give that huge authority back to again. Whatever they thought of him when they voted for him in 2016, they have all this additional information. And so I think that the famous suburban female voters, the famous swing voters, I think this does have a terrible impression. And even in this case, what an image of him. Here his wife has a newborn at home, and he's running around with Stormy Daniels. It's very clear that he was with her at that resort. There's photographs of it. I mean, you really want to vote for such a person if you're, a suburban female voter, if you're a swing voter who has concerns about the economy or maybe the border? Is this really the messenger that you want to bring, whatever message it is? Why not give Biden another chance and vote for the new candidate in 4 years if you want the Republicans to come on? Why vote for this guy? On top of that, I do believe that insurrection case, the one in Washington, D.C. federal court, I believe that one will go to trial. This presidential immunity is not going to bar this case from going forward in the federal court in D.C. I think they're going to hear it in April of this month, later this month. And I think the decision is going to come down in May, the latest in June. And I think that the district judge, Chutkan there, is really ready to go. I think she should issue an order now saying if it's not going to be stopped any further on account of presidential immunity, you all get ready to go. Bring your motions, get your motions ready to go, because I'm not going to give you a lot of time to present them. If she has a status conference, let's say July 1st, and she brings them all in and says, look, this case is going to trial in September, and you get a ruling from a higher court, but I don't want to hear it. This case is going to trial in September. I don't see any reason why it couldn't go to trial in September. Pick a jury. That's very fast in federal court. I know this take longer than a normal case, but that could be very fast in federal court. Pare that case down. The special prosecutor should lead with his 3 or 4 best ones. The insurrection and the things leading up to it, the slates, the things that are just raw fraud by Trump. He's the only defendant in the case. Nobody else can get a continuance or have this problem or that problem. Trump will try everything to get a delay. He could be on trial September, October. We really could have a verdict. And it doesn't stop the Department of Justice from going forward. He asked for this delay. The 60-day rule before the election they've said already, they're not going to apply it, and it doesn't apply logically. He asked for all these delays, and he ended up 60 days before trial. That's not on the government. That's on Trump. You delay these things, and this is what happens. You get tried a month or 2 before the election.
Wow. That would be extraordinary for a couple of reasons. Just to have the focus of the nation on J6 again, the events, where the president was, what he said. I mean, I feel as though our memory is so short. We have this voracious appetite for news and these cycles of news that don't even last 24 hours. I think these reminders are important. That's why, I love the document case. That'll never happen because it's such an open and shut case. But the J6 case is of immense significance. And that's really provocative, David. Thank you.
Mark,
Look,
to remind swing voters that if you vote this guy in, this is the guy who doesn't plan to leave, okay? If you don't like this guy the next time, he may not leave. He didn't want to leave that time. And now he's put these people in place that make it even harder to oust him, even though he's the loser. He lost in 2020. He's going to lose in 2024, try to vault himself in there, right? You know what he's going to try to do. And if he somehow gets back in there, that he's not going to leave in 2028. Even if the country hates him, even if he does every disastrous thing in the world, he won't want to leave. Why should voters take that chance with our democracy? Can I mention one last thing? I used to be on with Dan Abrams a lot. He's on News Nation, and I'm on with him at 2:00 our time today to talk about OJ. Like we talked about OJ and being an OJ commentator back in the day, and that remarkable.
Yeah, Dan Abrams really made his bones on some level. I think during that period as well on Court TV, as I recall.
Yep, and we're talking at 2:00 our time today, Pacific Standard Time.
Oh, that's great. We'll check that out. I mean, remember him, Terry Moran. There were these guys who just came out, and Court TV really made such an impression. Of course, it went away, but it's great that this world of valuable commentary on the law is one that you've been at the forefront of, and I had forgotten that you were a very high-profile figure in that world of commentary on the O.J. Simpson case at the time. So it's great to be able to kind of relive some of that with you. David, such a pleasure and an honor to have you in the mix. And we'll look forward. We'll check you out on so it's on News Nation at 2:00 Pacific.
And what is that? An hour and a half.
Good stuff. All right.
So
David,
on
you're the
New
best.
Station, yes.
Yeah.
Great to be with you. Really
All right,
a pleasure.
David. See you, David. David Katz, everybody. Yeah, right on.
The Mark Thompson Show.
Hi, it's Mark, and I thought that was great. Hit the notification bell. You'll know whenever there's a new video being dropped, and please subscribe to our channel to help us save the universe.